You've been writing your brief, and now you're getting ready to file it. This video will help you check your work and understand what to do next. Many appeal briefs filed with the California courts are rejected. Why? Because they do not include the required information, are not properly served, or they're not in the correct format. Let's review some key requirements so you can file your brief right the first time. To get started, be sure you've reviewed the court's strict formatting requirements for briefs. You can find a full list of these rules on our website. Check that your brief meets the formatting rules for everything from page numbers to line spacing. Now let's look at the information that needs to be in your brief. Have you reviewed your brief to make sure that you've completed every section? It may help to have an outline of all the sections, which you can find on our website. Take time to compare the outline to your brief. Make sure you have finished all the sections. The most common reasons briefs are rejected are failure to cite the record and failure to provide legal authority. So let's look at them one by one. Your brief needs to cite the record. That means you need to support what you say happened by referring to the record of your case. Have you referenced the record on appeal for every event or fact that you include in your brief? Take time to review the statement of the case and the statement of facts sections in your brief. Does every event or fact about the case include an exact location in the record on appeal? Be sure that each citation shows the source and page number in parentheses. Remember, you can only refer to information that's included in the record on appeal. Next, check that you have provided legal authority. Whether you are the appellant or the respondent, you must include legal precedents to support your side of the appeal. Have you listed legal sources that show there's a legal basis for your argument? If you need help finding sources, visit a library where you can do research. Ask a librarian to help you find resources in the area of law that your case involves. On our website, you can find a list of law libraries in California. After you've finished writing your brief, be sure to complete the Table of Authorities section. This is where you list all of the legal authorities and their page numbers in your brief. Now let's review some other important requirements for filing your brief. Have you included a certificate of interested entities or persons? It should be the first page of your brief after the cover. This is where you list the names of all the people and entities, which could be a business or organization, that have an interest in the outcome of your case. Both the appellant and respondent must provide a certificate of interested entities or persons, except if your case is a family, juvenile, guardianship, or conservatorship case. Even if you previously filed the certificate, you must include a copy of it with your brief. Next is your brief within the length that is allowed by the court. If you prepare the brief on a computer, it must have a certificate of compliance, saying it is 14,000 words or less. If you prepare the brief on a typewriter, you do not need a certificate of compliance, but your brief must be 50 pages or less. If you want to file a longer brief, you must file an application with the Court of Appeal and provide a good reason. The presiding justice will decide whether or not to let you file a longer brief. Moving on, do you plan to include attachments to your brief? There's a strict rule that you can only include 10 pages of attachments, unless you get permission from the court. And you can only include exhibits or materials that are already in the record on appeal, or in rules or regulations related to your appeal. Next, are you planning to submit your brief electronically or in paper form? The rules are different depending on how you file. Check with your Court of Appeal to confirm the specific filing and copy requirements in your case. No matter how you file, you always need to serve a copy of your brief, which means deliver a copy to the trial court and all the other parties in your case. You need to give the court proof of service, which is written proof that your brief was delivered by mail, in person, or electronically. And you need to get proof of service before you can file your brief with the court. Do you know what your proof of service requirements are? Check with your Court of Appeal to confirm who needs to receive a copy of your brief. On our website, you'll find a form that you can use for proof of service. Next, do you know your deadline to file? You should have received a notice from the court with a deadline to submit your brief. If you need more time to prepare your brief, you can agree or stipulate with the other parties in your case to extend the deadline. Or you can file an application with the Court of Appeal to request an extension of time. Note that the court does not send a deadline notice for the respondent's brief or the appellant's reply brief. Finally, as you prepare to file your brief with the Court of Appeal, be sure to carefully review the California Rule of Court 8.204 on how to format a brief and what to include. Remember, your Court of Appeal website or self-help center is also a good place to get information. Thanks for watching this video on briefs. On our website, you can find resources to help you complete and file your brief, including sample briefs, electronic forms, and more.